The results of the parking charge notice appeal are in, and you probably won't believe it. Stay tuned. Welcome back to the channel. As promised, I said I would come back to you with the results of the parking charge notice appeal that I filed. For those of you unfamiliar, I, for the first time, I think ever, received a parking charge notice. I've been given a penalty charge notice before, which I successfully challenged because the signs were covered in snow. This was so long ago, I probably won't be able to find a photograph of it to prove it to you, but the sign was covered in snow, which is a valid reason for the penalty charge notice to be revoked. In this case, I received a parking charge notice. Now, at the outset, I will just explain very briefly to those of you that have not watched my previous video, which I will link in the description below, that a penalty charge notice is different from a parking charge notice. A penalty is a fine, a parking charge is not. The principal difference being a penalty is a fine and a parking charge is akin to an invoice. It's not quite an invoice. It is notice to keeper that you owe a certain amount of money for alleged breach of contract, which they must ultimately prove in court if they want to really extract the funds from you, at least unless you admit to it. They usually include terms such as it will be halved or reduced within the first 14 days if you agree to it and pay it and so on. And they usually include terms that you can appeal it. Now, you might have noticed from a previous video that I also said that I would challenge this if it went to court on the basis that they used a PO box, which is not a geographical location. Now, whilst this has not been tested in court, the short version, the condensed version of that video is that if they use a PO box, it is not a geographical location as required by the Consumer Contract Regulations 2013, which are binding on any trader in any contract between a trader and a consumer. And as a slight tangent, if a trader asserts that you are not a consumer and that you must prove that you are, that's wrong. They must prove that you're not, but we digress. Coming back to the point, as promised, I said I would come back to you with the result of the appeal that I filed and explain the letter that I sent with it and whether or not that was successful. So as promised, word for word, and literally in Word, is the document shown on screen. This is what I sent, and the result is to come. I sent the following. Dear Parking Charge Company Redacted, I'm writing to appeal against the parking charge notice issued against my vehicle. So I did it. I told you on that day that I did it. I'll link that video in the description below. You can see the story through from the beginning. The reason given for the charge was no valid ticket or permit displayed. Now, as I said to you in that previous video, I disputed that because I was displaying the permit, albeit was on the seat, and I give the reasons for that in this letter. I maintain that the PCN has been issued unjustly, as the vehicle in question was parked correctly within the allocated bay for the address which is redacted and was displaying the requisite parking permit. The parking permit, though not on the dashboard, was displayed clearly on the front driver's seat facing upwards. That's important so that they can see it. I mean, I attached a photograph, so it's clear anyway. Notably, I have photographic evidence proving the visibility of the permit from the point at which the parking attendant would have stood to place the PCN on the vehicle. It was positioned there potentially because it may have been displaced due to the windows being ajar to alleviate the summer heat. Now, at this point, I'm going to pause just to say that it is very important that you keep the evidence of anything like this, because if you want to prove your case in court, you need really to prove that you have the evidence to back up your claim. And to that end, I've released an app called Proofify with the assistance of a very talented developer, which you can use to save the evidence, whether that is proof of purchase, proof of sending a product, proof of your vehicle's condition before you send it for an MOT, or in my case, proof that you are displaying a permit or that when you return to the vehicle, there was a permit visible. You can use Proofify as a vault to store this evidence in case you need it in court later. So check out the link for that in the description below, and that might help you in the future. It's developed by me with this developer, with what I would want to see as a lawyer going to court to argue these cases, the evidence that I would like to see. So this is your evidence vault. It's proofify.app, linked in the description below. Now, back to the letter. This I would prove using the app with the photograph that I sent to them of the permit on the seat. I said to the parking charge company in the letter, the parking permit, though not on the dashboard, was clearly visible on the seat, as I just read out. In addition, I have another photograph showing the PCN at the time I discovered it, which is important because if you take a photograph of the parking charge notice in situ and of your permit, if it is indeed on display as mine was, then the timestamps and everything else, which will be saved, by the way, by Proofify, it will save the evidence that you had that at the time, will prove on the balance of probabilities. Some people will scream in the comments, oh, you could have put it there, you could have lied. Yes, you could have lied, but I'm not going to lie. Most people don't lie. The court won't assume that most people lie. The court will assume that most people don't lie unless you have a reason to prove that they did. So on the balance of probabilities, the evidence that you provide, the court is going to trust unless there's a reason not to. So at the time I discovered it, taken seconds after the first image, this picture further confirms that the permit was visible at the time that the PCN was issued. At the time, another reason that Proofify is important. It will date and time stamp evidence that you upload. From these circumstances, it is reasonable to conclude, and bear in mind, I'm being nice and reasonable and polite here. You'll notice that not once have I opened with, I'm a barrister, you should listen to me, because I won't do that. I'm not, one, because I'm just not that kind of person. Two, I'm not allowed to do that unless, of course, I'm representing my own company as in-house counsel and things like that, which is fine. But in this case, it is me in my own capacity as an individual. I cannot and would not open with, I'm a barrister, you better take me seriously. Of course, I don't do that. From these circumstances, it is reasonable to conclude, I'm being reasonable here, that any person undertaking the duty of a parking attendant would have noticed, and indeed should have noticed, the valid parking permit. So if they're standing there, they should be able to just glance to the side and, oh yeah, there's a parking permit. They should see it. And if they didn't see it, they should have seen it. So it would be reasonable to suggest that they should have seen it. Then I go on to talk about the terms of the contract. Now, many people will argue that there is no contract. Well, that depends on a number of things. On the face of it, if you drive into a car park and you park, you're accepting the terms of parking, save for a few technical arguments that I might make, such as the PO box argument that I've just briefly discussed, which, again, I'll link in the description below for the full video. But all that aside, you are impliedly accepting the terms of a contract on the signs, so long as they're clear, when you drive in and park. Now, when talking about that contract, I said the terms of the parking contract as stipulated are as follows. Vehicles must be parked in an allocated bay and must display a permit. Now, those were the two predominant clauses in that contract. And if you fulfill those terms, there's no breach. So I assert and aver that my vehicle was indeed parked in the allocated bay of redacted address, complying with the first term. And it was displaying a valid permit, albeit on the driver's seat. I concede that it was on the seat, not on the dashboard. So I'm being completely honest here. I didn't just put it on the dashboard and say, hey, it was really on the dashboard, because knowing that they will have a photograph of the dashboard, probably. to show that there was nothing on the dashboard, which was right. I have to accept that, which nonetheless, in my argument, fulfills the second term. Therefore, and this, you're free to, by the way, you're free to copy this wording as you wish, only in so much as it might represent your circumstances. It's not legal advice, and it's not going to represent every situation, but you can, twist and tweak and change and copy and modify as you desire the wording of this, so as you wish. So aside from, producing any templates later and selling them or whatever, you're free to use this as you wish. That's my service to you as a viewer and a subscriber of this channel. Hint, hit the subscribe button. I might make that a term of the contract for using the template. Therefore, I assert that there's been no breach of the parking contract, as per the ruling in Beavis and Parking I 2015, UK Supreme Court, number 67. This is just a number, by the way, of the cases that the Supreme Court heard that year. A PCN can only be validly issued where a motorist has not complied with the terms of the contract, which is not the case here. Again, I'm being firm but polite. Additionally, I wish to raise concerns about the readability. This is a tangent, as if to say, I will look at further details which may become necessary. Readability of the fine print on the parking signage. It was really tiny. It's too small to read on entering the car park, and is unjustifiably include terms about costs being awarded on an indemnity basis. This was really interesting. It had words to the effect of, you will be liable to costs on the indemnity basis. Now, costs on the indemnity basis is a way for the court to punish you if you've either behaved badly or your claim or your defense is rubbish, and the court says you need to be penalized for costs. So you get an increased level of costs against you, and almost like a fine on the costs themselves, but awarded by the court, because the court has the discretion to award these costs. But a contract does not. You cannot, in my view, and arguably I'm sure most barristers would agree with me, you cannot agree contractually to costs awarded against you in a case on the indemnity basis. It's just not really a fair, certainly not in a consumer case. It's not a fair term of the contract. So it will be unenforceable in any event. Businesses, more arguable, but still probably not. The Unfair Contract Terms Act will probably come into account for businesses there anyway. A power that resides solely with the court, and not a provision that can be validly included in the contract, as I set out there. Furthermore, to mitigate any unnecessary costs to the parking charge company, which I've abbreviated, I'm filing this appeal on the same day that the PCN was issued. So I am mitigating, because you have a duty to mitigate any costs. Now, there was one suggestion that I should ignore them and let them try and find out my address and come back to me weeks later and all that sort of stuff. But then I lose this opportunity to mitigate any unnecessary costs to them. I'm being fair. I genuinely don't want them to go to unnecessary expense, because I have a valid reason to say that I'm not in breach of contract. So I don't want to waste their time. I don't want to give them the runaround. I don't want to unnecessarily inconvenience them. Okay, many people see them as evil, but they have a job to do. It's a necessity, because some people do abuse parking. So I'm not in any way criticizing parking companies here. I'm saying I'm trying to save them the time and the hassle of chasing me unnecessarily. Plus, it'll be favorable to the court later, because I don't want to be seen by the court as wasting their time. So I'm filing it on the same day as the issue. Given the circumstances, I kindly request that you revoke this PCN. If this matter cannot be resolved at this stage, please consider this letter as a formal request to provide the necessary details for the matter to be escalated to the independent adjudicator. And thank you for your prompt attention in this matter. So I'm being perfectly polite, and my request to them is to consider this and consider my arguments that I am not in breach of contract. And I'm just pulling up for you the response from the parking company. This is the response, albeit a extract from the response. Further to your appeal received on the same day regarding the above parking charge, I've now had the opportunity to review this case and my findings are below. Having considered the content of your appeal, we are prepared on this occasion to cancel this parking charge notice as a gesture of goodwill. Now, many people will say, you know, it's right. It's not just a gesture of goodwill. What it is goodwill. Goodwill is not just they're doing it without an admission. I mean, it is without admission. They're not admitting that they were wrong. They are doing it as a gesture of goodwill. It is goodwill. I take that with the good spirit that it was intended. So that is a win. That is a successful appeal against a parking charge notice. You are welcome to extract any wording that you wish, so long as you understand that it is not legal advice. It is not going to necessarily pertain to your particular circumstances. You'll need to tweak it, and if you're in any doubt, you need to seek legal advice. But otherwise, feel free to use any of the wording that I've used there. The Beavis and Parking Eye case is an authoritative decision from the Supreme Court that parking charge notices are not a penalty. They are a fair levy of charges for alleged breach of contract. But nonetheless, it does say that it is not applicable unless there is a breach of that contract. And so as I set out, and the reasons that I set out therefore, I was not in breach of contract. And I'm very pleased that they've accepted my appeal. They've agreed, impliedly agreed, that I'm not in breach of contract. And as a gesture of goodwill, they have, as you can see here, decided to cancel the parking charge notice. And that is the result, ladies and gentlemen of my viewers. That is the result here. There is no ongoing case for me to follow through with you all the way to court, as I would have done. Now, you'll note that I didn't and I haven't named the parking company. I think that would be unfair. Even after the event that they've cancelled it, it would be unfair because it might cast them in a bad light in light of my first video. But just to say that I think that was a fair decision. And so if anyone from that company is watching, I thank you for it. I thank you for being graceful and for your gesture of goodwill in cancelling this parking charge notice. If anyone else has any stories like this that you'd like me to talk about and like me to give you my views on, albeit not a legal view, just a view for what it's worth on this channel, I'm happy to do that in future videos and to assist you in resolving these issues. But this just shows that was the letter that I sent. You can see there's no mention of me being a barrister. There's no strong-arming, no complaining, just a very polite but firm setting out of the facts as to why I am not, I say, in breach of contract. So I hope you found that useful. Please do remember to like the video and subscribe. And as always, see you next time.